Cool. Hey, everybody. Fearless leader Tyler Winder here. Taylor is maybe getting on here in a little bit, but anyways, very important call today. Stephen Kenny of Canner Law on the call with us. Stephen, if you want to introduce yourself.
Hi, everyone. My name is Stephen Kenny. I'm with Kenner Law and Associates. We're located in Boston, Needham, and I have two offices on the Cape. I've been a real estate attorney with Canner Law for a couple of years. However, I've been licensed and an attorney since 2010. So I've been practicing since 2010 and in this niche for about 10 years. So I represent developers, buyers, sellers, and lenders, as well as landlords on real estate related matters.
And actually, we can add it to your resume. You're actually part co-founder of Winder Realty because you got the license to get everything up and running.
There you go. Yeah, I did. I got my broker's license so that in its infancy, everything could get off the floor. So
yeah. So real estate attorney, I need to bring you in when? If I am an agent, I'm representing a buyer, a seller, I get it under contract, it's not yet under contract. When do I call you and say, hey, I need you, or do I even need you? I guess I should say.
Right. So that's a great question. I think that there's what people typically do, and then there's what I tell people to do. So I'll kind of answer both questions. Typically, a real estate attorney will say, talk to me after you have an accepted offer. Maybe talk to me even after you go through inspection contingencies. Then I'll deal with drafting the P&S. I'll deal with repair riders, because a lot of attorneys, we bill out on what's called a flat fee. Like we kind of like an agent, like we don't get paid unless the deal closes. So a lot of attorneys in my industry will say, I don't want to start working on a file until I know it's likely gonna close. Like I know the offer is accepted and I know it's gone through inspection, and maybe there's some issues that we have to work through, but I don't want to waste my time drafting a P&S, dialoguing with the client, and things like that. So a lot of attorneys will tell you, talk to me after you have the offer accepted. That's not how I do my business. I do my business of you call me, you text. Tyler can attest to this. Like call me and text me. I'm happy to be a resource. Don't FaceTime me at 3 o'clock in the morning. However, if your client is thinking about a property and they have a question about a specific contingency, whether to waive it, whether or not to waive it, do they have questions about boundary lines? Do they want a preliminary title report run? Like what additional questions? To me, that's a value that I can add to the agents that I work with, the brokers that I work with, that then can be passed along to the clients, of giving that assurance of, okay, we want to make sure that this escalation clause is worded pretty tightly. We want to make sure that if we're waiving some contingencies, are we exposing ourselves and creating too much liability? So to me, I always tell people, I say, involve me when you have questions. Typically, it's once the offer is accepted, if it's a, clean type of situation. But you know what? This is real estate. It's not always going to be smooth. And if we can kind of address things up front, and avoid, certain protections that we can put into the offer to purchase that then carry over to the purchase and sale, that's what's key. So if we build that in at the infancy and before the offer is even accepted, that can be key to making sure that the transaction is pretty smooth. So I say involve me as early as you or your client want to. Happy to chat with you, happy to chat with the client, kind of explain what my role is and explain what the process is from my standpoint.
And does a buyer or seller need to have an attorney, or can they represent themselves? How's that work?
Technically, if you're a cash buyer and you're not getting title insurance, you can buy a property without an attorney. Do I recommend it? As an attorney, I'm going to tell you, no, I don't recommend it, because I'm an attorney and I want to get paid. But realistically, one of the biggest things that people don't, unless they've bought or sold real estate a bunch of times, they don't really get what title is and what type of, again, we're going to go back to liability. That's, as an attorney, that's what I revert back to. They don't really understand what they might be getting themselves into. So cash buyers don't necessarily need an attorney if they're not getting title insurance, but in terms of marketability of title, especially if they're a developer and they're looking to turn around the property, we want to make sure that title's clear. If the title's not clear, then the title insurance company and the attorney will work with the client to correct that so that they've got clear and marketable title. As a seller, I encourage people to have an attorney, because what's going to happen is my fee, which again is a flat fee, if you don't do that, the buyer's attorney is typically going to say, I will draft the P&S. It will be extremely in favor of the buyer. It won't be a balanced P&S. It won't be in favor of your client. They're going to be willing to draft the deed. They're going to charge your client to do that. They're going to charge your client to obtain the payoff. All of these little things are going to add up to be pretty much what my fee already is. Meanwhile, your client has exposure, excuse me, doesn't have an attorney, doesn't have anyone that they can ask questions to, and they also have to attend the closing. When I represent a seller, it's under POA, so they don't have to attend closing. You don't have to attend closing. It streamlines the process. And when I said that they don't have anyone to ask questions to, remember, they may wind up asking you questions. That's going to be a problem, because you are not allowed to answer legal questions. If you do, what's the keyword? Liability and exposure. Is that agents are not allowed to practice law. It's against the Realtor Code of Ethics for the unauthorized practice of law. It's a license violation. So you don't want to answer questions. So that's why I like working with an agent where, I don't know how to run comps on a property, so I'm going to defer to you. But if you have questions about legal matters, then you can defer to the attorney that your client's working with. And that's where it comes down to. And realistically, when a person is buying a property, the majority of them are buying it with a mortgage. So they're working with a lender. The lender is going to require an attorney, what's called a settlement agent. That attorney is working only for the bank. What we do is typically we will represent both the buyer and the seller simultaneously in what's called a dual role capacity. It allows us to do the work for the lender as well as the buyer and reduce our fees. So a lot of times attorneys will charge a reduced fee for what's called a personal representation if they're representing the attorney, or excuse me, the buyer as well as the lender. Sometimes we'll waive that buyer representation altogether. Lenders set what's called the settlement fee. Then there's the personal representation fee. So those are the two attorney fees that somebody pays for when they're buying a property and they're getting a loan.
And your fee comes out to what? Like, let's say I'm representing a buyer. We're talking about fees that are going to come up outside of your down payment. You have down payment, what you're putting towards a property, and then you have closing costs, pretty much what the bank is, legal fees, stuff like that. What is a legal fee, like your flat fee with a, let's call it a buyer buying a first time house?
So the lender sets with our office, that's what's called the settlement fee, which is bank attorney fee. And that, depending on the lender, ranges from $695, $895, $995, somewhere around there. I usually charge $535 as what's called a personal representation fee. That's because that $895, $695, whatever it may be, is what the bank is paying our firm for the work that we do for the bank. That's generating the CD, that's generating what's called the CPL, which is the certified protection letter. That's sending over the title work. It's doing all the stuff on behalf of the bank. That $535 is the fee that I typically charge the buyers for the work that I do for them. So that's going to be their purchase and sale fee.
Got it.
Yeah. So, and that's kind of that interaction. So that's the amount that the buyer is looking to pay. Now, if it's a cash deal, it's a little bit more. It's usually around $995 because we're not making the money on the settlement charge from the lender. So we're kind of stealing from Peter to pay Paul in terms of increasing one fee if one goes down.
And you're saying the settlement fee, call it $995, for example. If you represent the bank and the buyer, you potentially can waive that. So maybe it's only call it $1,000 for the representation.
We can't waive the settlement fee because that's the bank fee. What I can do is I have some wiggle room on that personal representation fee. So that's where if the lender is going to set your closing costs. So your closing costs are going to be your down payment. It's going to be your recording charges, which are from the registry of deeds. There's no wiggle room on that. It's your escrows, which are based on your taxes and your insurance, things like that. Where I have wiggle room is that $535, which I also hate to say, I mean, there are attorneys out there that charge way more than me. There are attorneys that charge less than me. What I look at it and say, what is the value? Just like there's some brokerages out there that are kind of discount brokerages, is that you have to value your own expertise and what you bring to the table. And I think that's true with anyone in this industry and anyone in any industry, is that if we're all chasing our way to the bottom, we're not valuing ourselves and our expertise. So I usually charge the 535, but that's something where if you say to me, listen, my client is a first-time buyer, things are tight, I talk to me on a case-by-case basis. I can see what I can do.
And so going into an individual transaction, are there certain things that us as agents can look out for like big no-nos? You can't buy this property, you can't pursue this because, I mean, you mentioned clear title. What is that? Like, are there pitfalls that we can be looking out for to protect our clients moving forward?
So I would say, when you're, are you talking about from like a buyer perspective?
Let's say buyer perspective.
Okay,
Yeah.
so
I'm going to bring someone to buy a property.
One of the biggest things that I see is
Uh-oh. Steve, you're frozen. Maybe. Kevin, is Steven frozen? Who's frozen?
Yeah, Steven's frozen.
Okay. Yeah, so Kevin, while Steven hopefully gets unfrozen here in a minute, we'll see how long it takes. Bring him in right off the bat. If you're looking to bring in a client, or bring in a buyer, seller, any questions that you have right off the bat, bring to Steven. Bring to someone like Steven if you have other attorneys that you work with. The more conversations that you can have with them early is only going to protect your client. And at the end of the day, that's the only thing that matters. So like, if I'm writing an offer, I call Steven. I mean, not necessarily writing offers now because we've done it so many times, but during negotiations, if something weird comes up, hey, this is an estate, how should I word an offer to protect ourselves if we're going into an estate? License to sell, when do we close after they get licensed to sell, stuff along those lines. Bring to Steve, because like he is a wealth of knowledge. So there's always going to be something that you haven't had in a previous transaction that you can bring to an attorney, because it's like, hey, this is weird, I haven't had this before, what are your thoughts with X, Y, and Z? And I mean, these guys have the legal notebook memorized where they can, sway you which way or another to make sure you're protected. But Steven, yeah, you definitely froze on us, so welcome back.
Sorry, no, that was 100% me. I apologize. So what I was saying is that the pitfall, the things that you're looking for are kind of if you see encroachments over property lines, again, you're not a surveyor, you're not doing a certified plot plan, but I'd say look for those things that are kind of those red flags of possible boundary disputes. If there's an easement, like a shared driveway or a front lot, a rear lot, if something might be a landlocked, those are things that you probably want to highlight as issues, as potential pitfalls, or at least things that need to be on your radar. So kind of radar, whatever attorney you're working with.
So let's call it a shared driveway. I'm representing a buyer. They're buying a property and it does have a shared driveway. They clearly listed on MLS, property shares a boundary with 124 Main Street. I call you and say, hey, there's a shared driveway on this property. So should I adjust an offer according to that? Or is that try to get the offer accepted, then bring you in for purchase and sale negotiation?
So there's kind of there's two schools of thought on this. Is that the less that you put in an offer, the less number of conditions
Okay.
that you put in there, kind of the more likely you potentially are to get that offer accepted. Then it gets passed along to the attorney. And what I would say is that I still haven't done my full title examination on the property. What I would do is I would make sure that there is a paragraph in the PNS that deals with marketability of title, things that are on record, things that aren't on record. What I might do is I might put a kick out clause in paragraph 30 or 31 saying, specifically subject to attorney review of driveway easement or something like that. I would think that if based on what you're saying is that, let's say they put it in the notes in MLS, they already know that it's an issue and they're actually proactively raising it for you. So I would maybe put something in paragraph 9 or item 9 of your offer to purchase, the additional provisions, and just say, subject to attorney review of driveway easement. Because what I don't want to have happen is if you don't put that in there, if somebody tries to fight me on whether that condition can move on from the offer to purchase to the purchase and sale. So there's kind of a mixed school of thought. So I'd say in scenarios like that, it might be good to engage the attorney that you're working with and say, is this something that we should put in the offer to purchase? Is it something that you could deal with in the PNS? What are we looking at in terms of, how complicated do we want to make this offer, or how clean do we want it? Like Tyler, I know Tyler, when you and I work on some, it's like your offers are no inspection, no mortgage contingency. They don't even have to clean out the property. A typical first-time buyer isn't going to want that. So we need to kind of weigh. Although we're using boilerplate offer to purchase forms, there isn't always a boilerplate answer. And I'd say this is when you said, when do you engage an attorney? This would be one of those ones where you might want to pick up the phone, shoot a text message and say, send over the MLS sheet, because attorneys typically don't have access to MLS. Send us the information and ask us to take a look at it.
So you're talking like, let's say me and you are doing doing a transaction, waiving all contingencies, we're cash, we close in 3 weeks, whatever it is. Where am I at fault to lose any? So typically you put like $1,000 down at offer, typically 5% down at purchase and sale. Those are your kind of your costs into the deposit, your escrow. At what point are those monies actually at risk? And is there a way, let's say after I put PNS down, that I'm still protected by a seller default or something like that? Or is if I can't perform, we can't perform, and that's it, I'm out?
So with that offer to purchase, let's just say $1,000. That $1,000 that you put down, it specifically says on the form, this is a legally binding contract. It's a legally binding agreement. There's case law about what's called specific performance. So that $1,000, if the PNS isn't signed, I'd say 95% of the time, the seller isn't going to fight you on that $1,000. If the PNS doesn't sign, the seller wants to just give you that $1,000 and move on from it, because they don't want to tie up, you saying that there's any claim, any legal right to the property. Like, they want to sign a release, give you your money back, and be done with it. It's typically when you're looking at that PNS deposit, which can be much sizable. Did I just say much more sizable? Yeah.
Yeah, you certainly did. You can't be making.
I've not had enough coffee yet today.
Yeah.
So that's where you're looking at it when you're contingencies. So if you have that a mortgage contingency, we're calendaring that date. I'm calendaring it, the lender is, the agent's calendaring it to make sure that we don't miss that date. Some attorneys put specific times in that, what's typically paragraph 26, and they'll say 5 o'clock. So that means that at 5:01, technically deposits are at risk if you don't have your mortgage commitment. Even if the mortgage commitment has issued, if suddenly the seller doesn't perform, the property isn't in the condition that it was supposed to be in, if there's a new title issue, if it's a condo and there's a special assessment or something like that on the property, your deposit is still refundable. If the seller can't perform, you can either try and force the seller to perform, or you can terminate and you can get your deposit back. So
because the seller hasn't given the property as it should be delivered, they're at fault, not us, even though my contingencies have expired.
The seller, this entire process is contingent on the seller being ready, willing, and able to perform. So if they're
Hmm.
not able to perform, if they don't actually, that's why when you write an offer, you typically write owner of record, because I could own my house as Stephen Kenny, I could own it as Stephen A. Kenny, I could own it as Stephen A. Kenny Jr. Like all of those little, the minutia of the deal is that if this, what if I signed that offer to purchase? If I signed the PNS and it turns out I don't actually even own my property, you know, it's not your fault that I lied and I signed all these things. Like your deposit would go back to you if you're the buyer. So if the seller has either fraud or just can't perform, or if the property is, you know, destroyed or damaged, and we can't pull the deal together, that the buyer's deposit would not be at risk in that case, unless the buyer has knowingly engaged in some sort of fraud or deception.
Hmm.
Yeah. So, and there, as an attorney, I will never tell you 100%, because every situation is totally different. But I'll tell you, I highly doubt a buyer's deposit would ever be at risk if the seller was in default. So,
Got it. And that's when you were frozen. We talked about that super briefly, is every single transaction is going to be different.
Yeah.
1,000%. Because there's as many deals as we do, there's always something that comes up that we haven't dealt with before. And I mean, that's just real estate, how it is, because not everyone is the same, and you have to be ready for, hey, I haven't seen this before. They threw in this language in here. What does that mean? So it's just having these ongoing conversations throughout is extremely important, because it's building up for the next one or whatever might come up in the future.
yeah, in my career, I just did rough numbers on this. I think I've done over 2,750 closings, and not a single one has ever been exactly like the last one. So every transaction is you're gonna learn something new from every transaction. Every transaction needs to be looked at under a microscope within the bounds of what that transaction is, because each one's going to be different.
Question from Kevin: do all the attorney fees get worked into the deal?
Good question, Kevin. So typically they do. So everything is itemized out on that closing disclosure. If you're a cash buyer, it's worked out on the HUD and itemized out. The only time a fee ever is not on there would be for attorney fees, would be if the lender does not allow that personal representation fee, that $535. If the lender ever said you're not allowed to charge that, then that wouldn't be on there. And then if the attorney shall say a legal services agreement, then the client would have to bring that to the closing. To me, if a lender tells me I can't charge that fee, I'm not going to try and backdoor that in. You know, I don't, because I don't want to do something that $535, although it's money, it's not worth it to me for the damage that it would do to the relationship I have with the agent, with the brokerage, or with the lender. So if a lender tells me I can't charge it, I'm not charging it. So,
but I mean, as agents, I think as we're having these conversations, let's say I did just meet a buyer, we are starting to look at properties. It's better to disclose all of these conversations or these fees and stuff right off the bat, so they're not aware of it. Because if you go line by line through a HUD, you might have 7 lines of legal fees, title fees, you know, whatever, and it just adds up. Like, wow, I didn't know all these unexpected fees. So I think if we come in early and say, hey, a part of your down payment, this is what you give the bank towards the property, your closing costs. This includes lender fees, attorney fees, title fees, and it might equal up to X%, so you're aware.
right.
And that's always better to probably say, you know, the attorney fee, you know, realistically, it's probably going to be between $1,000 and $1,500, just depending on all the back and forth and something that might come up on a property.
I never want a client to, you know, this is so stressful and it's anxiety ridden. It's exciting. It's so many things. I never want a client to come to me before closing or after closing and say, I didn't feel like you were forthcoming, or that you were transparent on that. So like, I have no problem sitting down with you guys. I've done it with Tyler before, and sitting down with you and saying, okay, from an agent perspective, let's go through a CD and I'll tell you exactly how much a law firm makes. I'll tell you how much I make.
Right.
And I'll tell client that too, but the BBO recently, has suggested that attorneys, there's a whole thing about title insurance disclosure and has said in terms of how we have to disclose that to our clients. So in my LSA, I literally itemize out every single fee, even if it's not when I get what's called the MLC, the municipal lien certificate, I'm not padding that. I'm not making money off of that. I'm getting that from the city or the town. And I tell the client, I say, listen, it's going to be between $25 and $50. That's how much the towns and the cities in the Commonwealth of Massachusetts charge us, and that's how much I'm going to charge you. So I like to be transparent with my fees so that there's no question about, being forthcoming.
This will probably be our last question. We have 5 minutes-ish before my free trial kicks us out, and I'm not going to be paying a membership on Zoom because I'm pretty cheap. But again, from Kevin, he's asking about, he said, for the title clearing portion, how does it work if there isn't a clear quit claim deed on file? So he's bringing up quit claim, if we can talk briefly about that. And then how does it work if there isn't a clear, if it isn't?
So a quit claim deed just means that you're conveying what you have in the property. So it's not a warranty deed or anything like that. In our area, it's, the majority of them are quit claim deeds. You also have, every once in a while, you'll have a life estate deed or something like that. If there's a title defect, that's when the seller, if they have title insurance, that's a good thing. That's why I'm like, you don't technically need title insurance. It is optional, but the lender has it. But the lender's title insurance only protects the lender. The owner's title insurance protects the owner. And what that means is that when you go to refinance the property or sell the property, if it turns out that there's a title defect that may have existed when you bought the property that the attorney missed, or if it's something that's come up since you bought the property, the title insurance will do what's called indemnification and undertaking. That means they will indemnify the new buyer and they will undertake to fix that. So then the
Indemnify the buyer meaning what?
So this is a seller issue. They'll tell the buyer, we will issue a title insurance policy with a known defect on it. We will make sure that you are protected so that when you go to sell the property, we will either work with the old attorney and fix it with them. And if not, we will pay out that loss. And we'll either fix it ourselves or we'll pay you out what the loss would be on that property because of that title defect. So that's what title insurance is, such small money compared to what it actually can protect you against. It's like auto insurance and home insurance. You hope you never have to use it, but when it's there, you're glad that you have it.
Sure. Wrapping everything up, do you have anything that you want to say to new agents that are coming on board, when they can reach out to you, anything along those lines to kind of wrap everything up?
All right, so when you can reach out to me, I think I've covered that, but you can reach out to me. You can shoot me a text, you can email me, you can call me. Text is usually the fastest just because emails can sometimes get buried. And phone calls, if I'm in a meeting, I can't always answer those. Don't ever hesitate to reach out to me. In terms of advice regarding like pitfalls, is that ask questions. Use Tyler's a great resource. Whatever attorney, if it's me, if it's somebody else, build your team, especially if you're a newer agent, and rely on that team. So definitely reach out to people, ask questions, because it's a lot easier to ask questions of the people you trust rather than trying to fix it on the back end. So it's better to trust your team, and I'd rather have you look stupid, even though you don't. Ask that question now rather than having to fix it later.
And you've done 2,700 plus transactions. Tips and tricks to do more business that you're seeing on the agent side?
So on the agent side, I think that, finding a way to make your, figure out what your value propositions are, figure out what your niche is. So it's like, is it going to be a specific neighborhood? Is it going to be a specific type of house? Is it going to be, how do you brand yourselves? All those things go into building your brand in your book of business. So you can't be everything to everyone. So I think, especially as a newer agent, find something that you're good at that's authentic to you. Don't try and be something that you're not, especially if you're just starting out. find a little niche and focus on that and be genuine to yourself and who you are, because if you're not genuine, people are going to read right through it. That's what I found, is that especially when I started out, I just tried to be everything to everyone, and after 13 years as an attorney, I've kind of tried to focus myself into the things that are genuine and things that matter to me, and also just trust your gut. If it doesn't feel right, it's probably not right. And if you're not sure, talk to Tyler, talk to me, talk to your trusted team members.
Love it. And I put your email in on this side, but for final wrap up, how can we get in touch with you?
So my cell phone is 781-375-6020. It's on our website. You can find me on Instagram. It's Close, KLOSE, with Kenny. But you can reach out to me via text, email, whatever works for you. And if you're having trouble getting in touch with me, if you don't have my contact information, Tyler can also push it out to you.
And email skenny@cannerlaw.com.
Yep. So it's SKENNY, not EY, just SKNNY@cannerlaw.com.
Perfect. Steven, thank you for your time. Anything comes up, of course, we'll be in touch with you, but really appreciate your time this morning.
Sounds good. It was nice meeting you all. Have a good one.
Thanks, Steve.
Bye.